Bryant on behalf of Sodexo Magic.
All right, thank you. And this is, well, latest motion for relief from judgment, is that correct?
Correct, Your Honor.
All right, you may proceed.
Thank you, Your Honor. Judge, this matter was previously before Judge Stokes. She ended up disqualifying herself on this case.
Okay.
I had made reference that she had decided the previous motion in my brief. Mr. Bryan informed me this afternoon that I'm wrong, that there was actually a visiting judge who was filling in for Judge Stokes when she was on a leave of absence. There's a confusion is he used her stamp to sign the order.
You should have done for her or something, but
Yeah.
it's her, she had a lot of staff who were not trained. Sadly, we don't have the kind of training we should at the courthouse. There are. And there's so many new people. There's lack training going on all the way around. So I apologize for that.
Yeah, that's not your fault, Judge. I just wanted to correct that because I did say that I referenced her opinion in there, but I guess it's really the visiting judge's opinion. And you know, sometimes mischief can be done when you have visiting judges coming in who aren't familiar with the case. But in any event, this is our motion for reconsideration of that order or relief from judgment. You could, there's various court rules that could apply to that. Regarding the general contractor, which is the Chrisman Company, and we did provide them a copy. I didn't receive a response from Chrisman. We served them a copy. And then I had my tech guy, because I thought it was so bizarre, I had him pull the access, because we provided it via Dropbox and we provided certain exhibits, and they did access the file on November 17th at 1:35 p.m. and then on November 12th at 5:12 p.m. That was provided. The motion's kind of straightforward, although there was a lot of briefing. So this incident occurred at the Dwight Rich School in the basement on October 28th, 2019. They were doing a rehab job down there, Your Honor. It's kind of an ancient basement. I mean, you had a dock and it was very dark. And off one of the tunnels that they were working on, there was a room that had a big industrial fan. The cover to the big industrial fan had been removed years before by the maintenance man. The maintenance man didn't want to have to deal with taking off 4 screws every time he replaced the belt on the fan or oiled it. So he decided he was just going to take the grate off and leave it there. This was then compounded by the fact that all the lights were out and no one had replaced the lighting. So they were doing a rehab project on the school, and the general contractor is Chrisman. That's who the subject of this motion is. And they came in and they were supposed to be responsible for general safety of all the subs, all these people that are working in that basement. And there was a lot of them. And they were supposed to provide coordination and safety. So previously, I think that the visiting judge got it wrong. I'm asking you to reconsider that decision under both the motion for relief from judgment and under 2.604A. If I may approach, Judge, I just highlighted it for you.
Always appreciate that.
I know.
I was just gonna go look.
But if you look, when there's multiple parties in this case, as you know, Sodexo represented by Mr. Bryan, and they're not opposing our motion, by the way, because it's good for them if the contractor is apportioned certain fault. Where there's multiple parties, this court has the discretion to modify an order before final judgment at any time. And that's what the court rule says, as well as your general powers under motions to reconsider and motions for relief from judgment. Aside from the fact that I just think that the visiting judge got it wrong, there has been an intervening change in the law. The Michigan Supreme Court decided the eligible, so the visiting judge dismissed the Chrisman in 2023. In 2024, our Supreme Court decided Al-Jamali, and that's EL-JAMALY. And that case is a common work area doctrine case where they clarified and corrected some rulings and some perceptions about the common work area doctrine. They made it easier to hold the general contractor liable for a common work area doctrine claim. I brought an extra copy of the case. I don't know if you've read it or you want it.
Well, let me ask you this, before we get to all of this, why, this is an ancient case, so there's no appeal. Well, time for motion for reconsideration has passed, all these dates have passed. Tell me about how I resurrect from the dead, a case that's been decided almost 2 years ago.
Yeah, so you have the discretion to do so, number one. Number two, there's been a change in the law, okay, in Al-Jamali, which is from our Michigan Supreme Court, so we couldn't have foresaw that. And the visiting judge who was deciding at the time didn't have the benefit of the Al-Jamali case. So he was relying on case law at the time that has now changed. If you don't do this, let's just play this out, right? We haven't forfeited an appeal against Christman. If you don't do this, we're going to go to trial against Sodexo. Sodexo isn't going to be able to blame Christman as a non-party because the court has determined, at least the visiting judge determined in 2023, that they shouldn't be part of the case. So they're not going to be able to blame them in trial. Let's say we get a huge verdict, which I'm going to ask for a huge verdict in this case, huge, massive. Then they're going to say that Christman should have been in the case. We're still going to file our appeal related to Christman. If the Court of Appeals says, you know, under this Al-Jamali case, the visiting judge got it wrong, we're going to have to do this all over again with both parties. From a practical standpoint, it doesn't make any sense.
Okay, but keep in mind, we are in 2026 and the Al-Jamali case is July 2024. A year and a half ago.
Yeah, I wasn't involved in the case back then. I can't speak to what should have been done or wasn't done. You know, I'm just trying to make sure that we go forward from here on the right way and that everything's correct. That's what I'm trying to do. I know this court wants to do that as well. You inherited this case. This wasn't your case either, right? And so now you step into this case and you're trying to make good rulings. It makes sense to have them in the case. The law supports having them in the case and the facts support having them in the case. You have the discretion to do it. It's clear under the court rules. I'm happy to tell you why you should allow them in from a factual standpoint, Judge, if you'd like me to go over that.
I'd like to hear your response.
Judge, Mike Bryant, on behalf of Sodexo Magic. I don't necessarily disagree with Mr. Marco. I thought Christman should have been in this case all along.
Okay.
And I also disagree with the visiting judge's ruling on that. Now, you asked about bringing them back in and the status of that. My recollection is that the majority of the depositions that were taken in this case were all done when they were still in the case, is my recollection. It deposed all the Sodexo people that there is, and I believe they were present for most of those depositions. Some of their people were deposed, some of Shaw Winkler's people were deposed, and they were involved at the case at that time. Then we had the motions for summary disposition that were filed by all the defendants at that time. And the visiting judge denied my motion and granted the other two defendants' motions. And then at that point is when we had the majority of the delay associated with this case, because after that motion, I then filed an appeal as to the denial of the motions against Sodexo Magic. And that was a significant delay in this case because of those appeals. So during those appeals, there really was not much done in the way of any discovery wherein Crispin would not have been involved and available to it per se, as far as the substance of the case goes.
Okay, let me just ask this before I make my ruling and close. I don't think either one of you have addressed. Now, let me just flip it. I understand your argument is that there's going to be harm if I don't grant it, but is there harm if I do grant it? Let me flip that side. Do you understand to either side? the destruction of evidence or anything else that legally we were gonna have a problem with. I mean, I was a trial
Yeah.
lawyer, I get it.
Yeah.
And so passage of time is a problem sometimes.
sure.
I don't know, you both know the case much better than me.
If they were a completely new party, yes, I think that would totally, we would have a much different argument right now. We're gonna bring them in, we have a trial date scheduled June 2nd. That would be a lot of prejudice there. They're not a new party. They've been on this train the whole time. They just happen to get off at the end of discovery. We're just gonna put them back on again because we're all going to the same place, which is ultimately gonna be the Court of Appeals. So
I'm sorry, as to your client, would you agree with what was just said?
For the most part, yes. It's my understanding that there was preserved in the original motion hearing, cross claims that were filed by Crispin Company against Sedesco Magic and against Shaw Winkler. Now, those were preserved in that original order. I don't know if there's any basis because there was no contract between my client and anybody involved in this case. So I don't think there's any prejudice to me if they get back in, because it's my recollection is they were involved in almost everything done.
yeah, they still have claims. I don't know if that was made, I didn't make that clear. They are claiming, they still have claims against Sedexo, which were held kind of pending the outcome of the case.
Okay, and the trial date of June, is that enough time for the remaining discovery? This discovery's gonna have to be opened.
Discovery's already opened right now. We were here before you, so there's no more liability discovery that needs to be done. It's simply updated treatment records, which is already being done. In fact, Mr. Bryan has a IME next week. We've already done one IME and there's one more. So that stuff's already being done. It's just would be updated treatment records, essentially. We have the same experts, et cetera.
Okay.
Yeah, I don't know, as far as I'm concerned, there's no liability discovery that needs to be done. Like I said, everybody from my company who had any hands on anything has been deposed. That's all done. We are still doing expert discovery. We're still doing some medical examinations. We have an issue pending regarding neuropsych evaluations and terms and conditions. But other than that, basically, it's just the medical that's continuing and ongoing at this juncture.
All right, for meritorious good cause has been shown, and this is also based on equity, judicial economy, and justice. I'm going to grant you the relief you seek and open this case up. You'll prepare the order
Thank you, Judge. Do you want us to do it right now?
whenever you like. Right now is always good.
It's always good. Yeah, okay, we'll just
We
take
have
a,
blank order, so you can go back and prepare it and text it or to us and print it, or however.
whatever the court wants.
Whatever's easiest.
We'll do whatever you want, Judge.
Great. Do you gonna give them a blank order?
Yeah, we'll.
There's some on the desk over here. Somebody left.
Oh, perfect.
Oh,
Somebody
wow.
left the whole folder. Maybe this is where they went missing.
All right.
Should this be over there?
Yeah,
There you
Probably.
go.
it looks like somebody just left them there.
Somebody just left.
Thank you.
All right, thank you, and that's all that we needed to deal with today, right?
Yes, Your Honor.
Thank you. That's all for this purpose.
Did you get your copy? I was on for 1 o'clock, the motion to compel notice.
Are they showing up? Probably.
It's 1:30.
All right, so I'm just gonna make a record. This is docket 25-617 and O. Wow, Kevin Arnold Washington versus McDonald's Corporation. There's a motion to compel schedule at 1 o'clock. It is now 1:32. No one has shown. I am considering that motion withdrawn.
Yes, I are. Yes, Alan, Ms. Dickerson. Should correct, yes, I are.
Let me see, where is that? All right. This is People of the State of Michigan versus Brandon Michael Ramier, docket 23513 FH. Counsel, your appearances for the record.
Hi, Your Honor. Elizabeth Allen on behalf of the people. I can't turn on my video because it says the host has stopped it.
Oh, well, he's going to like right now.
Thank you. Elizabeth Allen on behalf of the people, Your Honor. Good afternoon.
Thank you. Good afternoon.
Good afternoon, Your Honor. Kim Bickerstaff on behalf of Mr. Raymer, and I do see Mr. Raymer present in the MDOC room.
All right, sir, I don't know if you have anything to add to this, but please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Thank you. Put your hand down. Counsel, you may proceed.
Thank you, Judge. This case has gone on a bit long, and I apologize. I know it was in part due to Your Honor's schedule and my schedule, and we kind of got off track for a little bit. So I apologize for the delinquency in this motion. But you may recall in October of 2024, we came before Your Honor on a motion because the statutory maximum was incorrect and the Tanner minimum was incorrect. And I think both the prosecutor and I believed that you were going to be ordering a resentencing to be held at a later date, but we went ahead and did it at the same time. And I don't know that either of us was completely prepared to do that, but Mr. Raymer did have some additional arguments that we raised in the first motion about the PSAR and some of the things that were contained within it. And during that initial hearing, Your Honor did make some rulings on which the prosecutor and I agreed. First, that any allegations made regarding his ex-girlfriend Cammie's alleged rape, and that should have been struck because it was uncharged or unprosecuted, as well as the victim statement that's contained in the PSAR by Cammie, the ex-girlfriend, is she's not a victim in this aggravated CSAM case, and that should be struck. But when we continued on, it seemed from the original record that it wasn't quite clear about what rulings were made, and it looks like we needed to go over it again. So the prosecutor and I did meet, tried to come to a resolution on what we would agree to, and we still need Your Honor to rule on some of these items.
Well,
so that we have a
outline
clear
what
record.
specifically? I mean, didn't I change the Tanner Max, so didn't I fix that?
Yes, that absolutely, Your Honor. The sentence was fixed. It was more about what was contained in the PSAR, and there was a lot of information provided by Cammie and Mr. Raymer's ex-wife about fantasies and acts with dolls and things that had nothing to do with possession of CSAM. And in order for
Okay, let me just stop you there. I'd like to
Okay.
get to the chase. You can argue until the cows come home. Let's just get to the bottom line. So
Okay.
let's go page by page and see what
Great.
you want, and then let's hear from the people. Is that all right with
Perfect.
you, Ms. Allen?
Yes.
Great. So let's start on page 1, evaluation plan. Any proposed changes?
No, Your Honor, it's just under description of offense narrative, if you want to
Okay,
just
that's on
flip to page
Page
2.
2.
Yep.
Yeah, okay, got it.
Okay, so the first, it looks like it's the third paragraph that starts, Cammie stated that Brandon had displayed, and it goes on there. Your Honor indicated during the last hearing that you did not consider any of this during the sentencing, and according to the rules, it should be stricken if you did not consider it.
Well, Judge, I think the situation is I think there was a little bit of both. You said you didn't consider it, but also we're not going to take it out because it was a statement by Cammie Veith. So it was our position that obviously we want the court to decide what, if you didn't consider it, it has to be struck, but it's our position in our answer that this court could properly leave it in, because it's our position that the fact that he has a collection of child toy dolls that resemble small female children was part of the underlying reason the police even gained access to his devices. This was all part of the search warrant underlying the investigation into his aggravated CSAM. So she gave all this information to the police. They get a search warrant, and then they come and we're able to find the aggravated CSAM. So in the PSAR, the circumstances surrounding the offense get to remain in there. So it was our position that it should stay in. And also because if we're looking at the offense itself of aggravated CSAM, the fact that we have to show, the prosecutor does, that he knew or reasonably should have known the person shown in the CSAM was a child and that he possessed and knowingly looked for the material. So the evidence of his sexual fantasies with childlike dolls in conjunction with the rest of his statements are relevant because they go to his knowledge that he's looking for CSAM, and that is part of the whole situation here. So I understand really the answer, Judge, is if you did not consider it whatsoever, I agree it has to be struck. But I think because at the hearing, we couldn't tell if you did or not, it's still our position that you can, and it should remain in, and that it was properly considered if you did. So I think that's really where we end up. Do you agree, Ms. Bickerstaff, I think?
I do.
Okay.
And this wasn't testimony. This was cut and paste from a police report. It's obviously unreliable hearsay. It wasn't
I wouldn't
spoken
say
during a
obviously.
preliminary.
That's just
Sorry about that. It was not testified to in a preliminary exam. And our position would be it doesn't belong in there. I mean, these were aggravated CSAM denotes a child of a certain age. I don't think that there's any question that these children were of the age they were. None of this needed to come in to prove that he knew the age of the children. So that's a red herring, in my opinion.
So I don't think that I considered the first few lines, but I know that I did consider later on the police report that, because I'm not striking this whole thing. I mean, I did consider some of what was in the police report that specifically related to the factual basis that was considered. And that would more be in the second full paragraph on page 3 and that information, which the foundation of which is the above paragraphs.
Okay, and Judge, we're in agreement. If it was something you did not consider, it should be struck. I think that's the law. So I'm not trying to argue that, we really agreed that we wanted clarification from the court on what you did and did not consider.
And Judge, what we would propose is maybe you just strike what you think should be stricken, and that way at least we have a clean record and we know, what appellate issues we might have, so.
I mean, the problem with with please, I don't have all this information. However, we did make, as I recall, an extensive record. So I'm just gonna strike the first full record, the first full paragraph, but I'm leaving from Cammy told police and on in, because I know that struck me when I read it, and I'm reading it again, and I remember that detail. I remember the above a little bit, but I think I skimmed down because that's not what I recalling the factual basis, what I focused on. So.
I'm sorry, Judge, I'm not following where you said you are striking. Sorry, I have it here. Could you just reiterate that?
Yes, just a moment. So let me just go to, I was just handed the transcript. So what I have struck is the paragraph at the bottom of page 2. So that's 1, 2, 3, 4, 5 lines. And then at the top of page 3, the 4 lines, I'm leaving the rest.
Okay, and then Judge,
it will start with Cammy told police the previous summer.
Okay. And then for the remaining paragraphs, those are all staying?
Those are all staying.
Okay, I know the prosecutor and I did agree to strike the second from the bottom paragraph on page 3 the information regarding the alleged sex without her knowledge. Miss Allen, I think we agreed through the PPO and then leaving those last two sentences. Is that your recollection as well?
Yes, and Judge, just
Okay.
to explain, because I know this all came from Cami, but we don't believe that that alleged and unsubstantiated assault that the court already said it did not consider it sentencing should be left in the PSIR if it wasn't considered.
Correct. And then
All right,
we
so
also
can you
agreed.
just wait a minute.
Okay.
Go back. So what specific lines is this, is which paragraph? Second to the left, second from the bottom, right? Which
Correct.
lines specifically? What's it start with?
All the way up to, it starts at the beginning and it goes all the way up to obtain a PPO. So it's only the last two sentences that are staying in.
Okay. So now that paragraph will start with police ran Brandon Raymer in lean, to the rest, right?
Correct.
Okay, now you can go on.
Okay. And then we also had agreed the victim statement entirely would be struck because she is not a victim to this crime, Cami. And Miss Allen agreed to that as well.
That's true, Your
Okay.
Honor. Under the Crime Victims' Rights Act, she doesn't qualify because it's aggravated CSAM.
Okay, that's struck. Anything else?
Well, I would take contention with a lot of these, I mean, almost every paragraph. So if Your Honor's indicating that you're not going to be striking any further, then at least I understand what the position is.
Well, you know, the problem is I did read the PSIR. Now, the couple of paragraphs that meant really nothing to me, getting to the heart of what the issue was, I've already struck, and you agreed to strike some others, so I think we've struck enough. I mean, this does all go to the factual basis that was made, what's left, and so I'm comfortable leaving the rest. I mean, I understand that on behalf of your client, you want it all struck, but that's just not happening.
I understand, Judge. The one other paragraph I guess I'd ask that you consider is on page 4. It's the second full paragraph or the third paragraph there about the interview with his former wife. I don't believe any of that is relevant to this either.
I think it's inconsequential. I don't know. Ms. Allen, for the record.
I agree. I don't have an objection to striking that, Judge.
I'll strike that. I kind of breezed through it as I went through it, so that's fine.
Okay, thank you, Judge. Okay,
Anything else?
no.
All right.
So an updated PSIR will be prepared. How would you like me to prepare an order also, or what would be best?
Might as well. I think an order would be appropriate, wouldn't take long, and I've made the corrections here, so we'll order an updated PSIR and then you both can, you know.
Okay.
Probation doesn't always get it right, so before you file a motion with me, make a phone call to them and say, hey, here's, you know.
I'm gonna send it to Miss Allen and hopefully we can get the order stipulated too. So, okay.
Great. Anything
Thank you,
else?
Judge. Nope. Thank you.
Nothing from the
Okay.
people, Your Honor. Thank you.
You too.
Have a good afternoon, Judge. Good to see
You too. Nice seeing you. Happy New Year. Sir, you can let them know that we're done, so you're good to go. All right, Happy New Year. At 25-3575 FH, people of the state of Michigan versus Anthony Lujabile. How do you say it? Thank you. Counsel, your appearances for the record.
Good afternoon, Your Honor. AP Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Brian Jackson on behalf of Mr. Lugaville, who is present in the courtroom for his plea.
All right,
May I approach?
you may, sir, if you could come up and stand next to your attorney. Thank you, counsel. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. And sir, do you still live on Old Lansing Road?
No.
What is your correct address? Have you put it on the form?
Yeah, I wrote it.
Right there. Okay, we'll get it from there. And who do you live with?
My mom,
Okay, and how old are you?
34.
And are you employed?
I'm working on it. I've been putting in job ads. So.
Okay, did you graduate high school?
Yeah.
All right. At the time of the offense that you're pleading to, were you on probation, parole, or bond conditions before another judge? And are you a US citizen?
Yes.
And you had no time to speak with your attorney regarding the plea? Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, cold, or other illness?
No.
On behalf of the people, for the record, what is the plea agreement?
Yes, Your Honor, the plea agreement is for the defendant to plead to count 2, receiving and concealing stolen property 1,000 or more, but less than 20,000. Upon successful plea and sentencing, count 1 and the habitual offender status will be dismissed. There is a killabrew to no upfront jail as long as the defendant agrees to any and all terms of probation, continues in substance abuse treatment, and follows all follow-up treatment, and restitution will be determined at the time of sentencing.
Full, fair, accurate, and complete, counsel.
Yes, Your Honor.
Thank you. Sir, was that statement of the people full, fair, accurate, and complete as to the agreement that you understand you're entering into?
I believe so, yes.
All right, did you need more time with your attorney, or have you had enough time to speak with him? Did you have enough time to speak?
Yeah.
All right, very good. And counsel, are you waiving reading, count 1 and the habitual offender third offense notice?
Yes.
As to the reading of felony information, count 2.
Yes, Your Honor. The people of the state of Michigan versus Anthony Lloyd Lugaville. The state of Michigan, county of Ingham, in the name of the people of the state of Michigan. Prosecuting attorney for this county appears before the court and informs the court that on the date at the location described below, the defendant in count 2 stolen property, receiving and concealing 1,000 or more, but less than 20,000, on or about June 15, 2025, at 3001 West Main Street, Lansing, Michigan, 48917, Ingham County, state of Michigan. The defendant did buy, receive, possess, conceal, or aid in the concealment of a utility trailer, stolen, embezzled, or converted property, knowing or having reason to know or reason to believe that the property was stolen, embezzled, or converted. The value of the property was $1,000 or more, but less than $20,000, contrary to MCL 750.535, subsection 3, subsection A. This is a felony that is punishable by up to a maximum of 5 years and or $10,000, or 3 times the value of the property, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by the trier of fact at trial. The court may order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yeah.
So you understand that stolen property, receiving and concealing $1,000 or more but less than $20,000 is a felony punishable by 5 years and/or $10,000 or 3 times the value of property, whichever is greater. The court will impose restitution to make the victim whole as a result of any personal or property damage. And if you disagree with the amount, Mr. Jackson will set a restitution hearing in front of this court. We'll have a hearing and I will decide the amount. The amount can go up, it also can go down. Do you understand all that? And sir, you signed the advice rights form. Did you read it before you signed it? You need to speak up.
Yes, ma'am.
Did you understand what you read?
Yes.
And if you had any questions about your rights, Mr. Jackson was able to answer those for you?
Yes.
Do you have any questions about your rights at this court?
No.
And do you understand that by pleading, you are giving up certain rights and defenses you would have had you had a bench or jury trial, such as presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense or to remain silent, and additionally, an automatic right of appeal if you were unhappy with it. However, once you plead, if you want to appeal, it becomes a decision of the Court of Appeals to appeal, and they will only accept your case if they think your issues are important. Do you understand all of that?
Yes, ma'am.
As to count 2, stolen property, receiving and concealing $1,000 or more, but less than $20,000, how do you plead?
Guilty.
And sir, did anyone force, threaten, or coerce you to plead? Did anyone promise you anything other than the plea agreement?
No.
So you would have to tell me now if they did, because if you come back later and you say I shouldn't have pled, I don't have to accept that and allow you to withdraw your plea. Do you understand that?
Yes, ma'am.
So you made the decision to plead after you discussed with your attorney, whatever it is you two discussed, looked at the evidence and you worked this out and you had an opportunity to talk it over with it, correct?
Yes, ma'am.
And you decided to plead after this discussion, or many discussions probably, yes?
Yes, ma'am.
And you've been satisfied with the representation of counsel?
Yes, ma'am.
Other than the plea agreement, has anyone told you what I will do at sentencing?
No.
Do you understand that if you violate bond or bond conditions or the law between now and sentencing, I do not have to honor the no upfront jail?
Yes, ma'am.
And if I don't honor it and you've done everything well, then I would allow you to withdraw your plea and this matter would again go to the pretrial stage. Does that clear to you how that works? So if I'm not part of the agreement between all of you.
Right.
So I could say, based on what I learned at sentencing, right now, I don't know a whole lot about your case. But when I'm fully informed, if I think that you need some upfront jail, I could do that, but I would be violating your agreement, so I would have to allow you to withdraw your plea. Okay, but if you violate the law or bond conditions, I can violate the agreement without allowing you to withdraw your plea. Does that make sense to you?
Yes, ma'am.
Okay. Sir, did this offense occur on or about June 15th, 2025?
Yes.
In the township of Lansing County of Indiana State of Michigan?
Yes.
At a specific location known as 3001 West Main Street?
Yes.
And you came in contact with or found a utility trailer?
I bought a utility.
You bought it, okay. And did you buy it under circumstances where you should have known that it was stolen property?
Yes, ma'am.
And did you thereafter come in contact with law enforcement?
Yes.
And did they arrest you on a warrant? Did they do an investigation? How did they figure this out?
They arrested me on a child support warrant and then they checked the VIN number of the trailer and found it was stolen.
Okay, so where was the trailer when they found it? Was it on your home property?
Hooked
or
to my
what?
truck and
In your
at a
truck?
park, I was at a park. Yeah, eating lunch.
Okay, and you would agree that although you bought it, you should have known based on the price of the circumstances
Yes, ma'am.
that it was stolen? And you went ahead and purchased it?
Mhm.
Is that a yes?
Yes, ma'am.
See, this record is for you, and if the court reporter can't hear you, it's gonna say, inaudible or whatever, that doesn't help your case, okay? So you just gotta speak up, okay?
Yes, ma'am.
All right. And did this trailer get turned over to law enforcement and perhaps the owner of it in the same condition that you received it in, or was there any damage?
I was told that the person got the trailer back undamaged, and there was no damage.
Okay, so you're not aware of any damage, is that correct?
Correct.
Okay. On behalf of the people, any questions?
Just briefly, Your Honor.
Well, wait a minute, you know what I forgot to ask, was the value of the trailer $1,000 or more, or less than 20,000?
To my knowledge, yes.
Council?
The people are satisfied, then, Your Honor.
Yeah. Council?
Satisfied.
All right, thank you. Our council order promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Thank you. Is the court compliant with the court rule?
Yes, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made that under influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea, therefore count 2 will enter. Count 1 and the habitual third offense notice in its entirety are hereby dismissed. Any outstanding warrants related to this file, if any, are recalled and dismissed. Do we have a sentencing date?
February 25th at 10:30.
Council, does that meet with your schedule?
Yes.
Okay. Couple things, looks like as to the charges that were dismissed, there's some contraband, so any contraband, is hereby forfeited. That's just following the law, but just so we make a record of that. And sir, you should go downstairs now and make your appointment with probation. If you do not have time to do that today, there's a phone number on that purple sheet. It's 517-483-6100. You have 24 hours to contact them and make an appointment for a pre-sentence investigation report. We can't proceed to sentencing without it, so it's really important you get it. It's just easier since you're in the building to go downstairs. Mr. Jackson can direct you further. And if for some reason you choose to call and you can't get hold of them, make sure you reach Mr. Jackson, because I have a standing bench warrant. If you don't complete that, I can't go to sentencing. So if you don't show up for the appointment you make, or you fail to make one, we just arrest you, and then I can promise you probation takes their sweet time to get you in jail, and I won't release you without it because we can't move forward. Does that make sense to you? So bond and bond conditions are continued. Now, are you currently in substance abuse treatment?
I went to substance abuse treatment and completed 30 days of substance abuse treatment.
And are you doing any aftercare?
I'm working on still getting my aftercare set up. They're having problems with my insurance.
Okay, all right, well, make sure you do engage in that. I'm gonna order that,
Yeah.
but if you show me through your attorney at sentencing and talk to probation about it, that you're engaging in all of these things early, that may very well cut your probation shorter. So I need you to stay law abiding, stay in treatment and all of that. So whether it gets cut up front or on the back end, that's up to you. Okay, does that make sense to you?
Yes, ma'am.
All right, so bond and bond conditions are continued. Anything else, Mr. Jackson?
No, thank you.